Oops. Okay. Welcome, everyone, and thank you for joining us today on Level Up Law. South Carolina Legal Services looks forward each week to leveling up your legal knowledge on the different areas of law that we practice in. So thanks for tuning in. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services. I'll be the host of the webinar today, along with our producer, Kenneth Elliott, from our IT department here at South Carolina Legal Services. Today, we are joined by SCLS attorney Leslie Fisk. Welcome, Leslie. Leslie is the managing attorney of our office in Greenwood, South Carolina. She's been practicing law in family court for many years here in South Carolina, and today she'll be providing information about common law marriage. It was recently abolished in South Carolina, but as always, when it comes to legal matters, there's more to it than that simple statement. So this will prove to be an interesting and informative presentation. So we welcome Leslie today. As you view today's presentation, please do remember it's not legal advice, but just general information for the public. You should always consult with an attorney for any specific legal issues that you have. At the end of the presentation today, we will provide information on how to apply for legal assistance at Legal Services. That is free to eligible citizens, and so we hope that if you need us, you will apply, and that information will be provided at the end. We'll also provide a lot of information on how to access our public information and resources, so definitely stay tuned. Kenneth will be posting a recording of Leslie's presentation on our YouTube channel for South Carolina Legal Services, along with the slides that she's going to be using today. Now remember, even though you will be in listen-only mode, be sure that you take advantage of this opportunity and put any questions you have for Leslie in the question box. Only use the chat box to let us know about technical difficulties that you might be having. And so hopefully, if time allows, Leslie will be able to provide some general information to answer your questions. Again, thanks so much, everybody, for joining us. And Leslie, go ahead and take it away.
Good afternoon, and thank you for allowing me to be here to tell you about what's new with common law marriage. So people have lots of questions about what common law marriage is. And one of the most important things that you should know is that what's different about common law marriage is how you enter into it. But once you are common law married, it is treated just like a ceremonial marriage. So on my slide here, I have two lists of some of the differences and similarities between ceremonial marriage and common law marriage. When I say ceremonial, what I mean is that you and your partner were married by a pastor, a rabbi, a judge, a notary, somebody with the authority to declare you married. And in South Carolina, you would get a marriage license, and then you would have the ceremony where someone declares you married. Common law marriage is different. There's no marriage license. There's no person declaring you married. With ceremonial marriage, you have a specific marriage date, which will then many people use as their anniversary date. Typically in common law marriage, there's no specific date that people can look to and say, as of January 3rd, 1984, we were common law marriage. It's usually more vague than that. There's not typically one set date. Ceremonial marriage is very easy to prove because you have a marriage certificate and you have a day where you were declared married by some sort of official. Common law marriage, on the other hand, has to be declared by a family court judge or a probate court. So it's much more difficult, it requires a court case, so much more difficult to prove if needed, if somebody's doubting that you're common law marriage. With both of these types of marriages, you cannot enter unless you are to the legal age that you can marry. So you cannot, enter into a common law marriage when you're 13, just like you couldn't a ceremonial marriage. Also, if you're currently married to someone else, you cannot enter into either a ceremonial marriage or a common law marriage. That's considered bigamy, and that second marriage is not valid. So with both of these types, you cannot have any impediments to enter into a marriage. A ceremonial marriage requires a divorce to undo it. So if you are married with the marriage certificate and the official, you're going to have to get a divorce. Same thing with common law marriage. If you're common law married, you still have to go through the court to get a divorce, to divide property, to divide debts, all of those things. So why does common law marriage exist? So I put up some dates here. Back hundreds of years ago, people couldn't get to the courthouse. They couldn't get to maybe a church nearby. They tended to not have education to understand all the laws. They didn't have money maybe to travel. So hundreds of years ago, common law marriage was created and made more sense to apply to those situations. It was brought over from England to the colonies, and that's how it became part of our common law here in the United States. Between 1800s and 1950, most of the states in the United States abolished it, but it was not changed in South Carolina until 2019. So as of now, there are fewer than 10 U.S. states where it is still an option to enter into a common law marriage. So once again, I talked about why this originally existed, the inability to travel in the United States. Some of the arguments about why it stuck around longer were that people didn't want government oversight. They didn't want the government in their affairs and the ability for them to declare whether they were married or not. Also, historically, children who were born to unmarried parents had more of a stigma against them. A long time ago, they couldn't inherit, and also they were just stigmatized in society. There were problems also for the partner who didn't earn as much or didn't have access to money, which is typically the female, though not always. And so if they weren't considered married, then that person would fall upon the state to support. So they would need welfare, or they would need the church to support them. And if you declared them married, then suddenly the other partner who has access to the money now has to support them. So there were many reasons the government also agreed that there should be common law marriage to avoid some need for welfare and instead put that burden on the person that they were married to. So those are all the reasons that common law marriage existed. And so what happened in 2019? There was this court case, Stone versus Thompson, and it was a couple who had been together for a couple decades, and they were divorcing, and one of them said we were common law married, and the other one said no, we weren't. Now, there are some reasons for this, how it would have benefited them in court, why they had those different positions. And so they had a big trial on whether they were common law married, because if they were common law married, then that would change how property was going to be divided and how money was going to work. So that was their interest. So they had more than a week of trial in family court, almost 200 exhibits, and more than 40 witnesses. So at this trial, typically, this was actually an appeal. It had been in the family court and had all those witnesses, and then it was appealed. And at the appeal, the court said, you know what, it's time for us to come in and not only decide this case between Mr. Stone and Ms. Thompson, but also to change how South Carolina looks at common law marriage. And so the biggest takeaway from that case is that you cannot start a common law marriage after July 24th of 2019. So that, I'm going to say that again because that's so important. You cannot start a common law marriage in South Carolina after July 24th of 2019. So that means if you were common law married before that date, you can still be common law married in South Carolina, but you cannot start being common law married. And the reason that they did that was to give people a little bit of notice. So people who have lived together for 30 years in South Carolina and who have considered themselves common law marriage can still be common law married. But for those people who haven't started that common law marriage, they're saying you can just get to the court, get yourself a marriage certificate, get to a pastor or a notary or judge, and you can now have a marriage, the ceremonial type of marriage. So I also did a couple of different things to tell future courts when a couple comes up and one of them says they're married and the other one says they weren't common law married. These next two bullet points are to help the judge decide how to determine whether they were common law married. In the past, before this case, the judge had a presumption or was sort of told to lean to the fact that they were common law married. In this case, took that away. Also, they changed the standard of proof that the person who's declaring this is a common law marriage has to prove. So they now have to prove more to determine that they were common law marriage. And this court case said that the main key element that someone has to prove to determine that they were common law married is this mutual assent, this desire that both of them intended to be married, and they understood that the other partner also wanted to be married, and they were now married. So those last three bullet points are mostly guidance to future judges trying to determine whether a couple was common law married. But understand that any couple who's trying to declare themselves as common law married would have had to start being common law married before July 24th of 2019. So after July 24th of 2019 going forward, your only way to get married in South Carolina is to go the ceremonial route, which is to get that marriage certificate, excuse me, a marriage license, and then to have an official marry you. So why did the court make this decision after all this time, hundreds of years of common law marriage? So they pointed to uncertainty, that when you have two options of common law marriage and ceremonial marriage, it's just very uncertain. It takes up court time. You can see how much court time that case took up. And it's just a big question of are we not, and how is that going to affect our different legal affairs? Well, this makes it more certain that if you started being married after that date, you had to get a ceremonial marriage or else you're not married. So just answering all the questions, making it more certain. They also pointed to that there are fewer consequences to being unmarried than there used to be. The stigma against children born to single parents is a lot lower than it used to be. Children born to parents that are unmarried can inherit property from them. It doesn't affect their inheritance rights. And also, unlike the way it was hundreds of years ago, if somebody, a single parent, wants child support, you can still get it from the other parent, even if you weren't married. So there are a lot fewer legal consequences and social consequences to being unmarried or for two unmarried people to have a child than there used to be. They also pointed to the ease of travel. It's a lot easier to travel than it used to be. Most of us have churches all around us or different places of worship, courthouses. They know people who are notaries. It's much easier to find those than it was hundreds of years ago. Also, the cost is relatively minimal to get a marriage license, and there's less confusion too. Just more certainty about what outcomes are. So if you believe you were common law married before July 24th of 2019, how do you prove that? Okay, so if you and your spouse agree that you're common law married, then it's not that difficult to prove. You both agree. But the problem tends to come when someone says there is a common law marriage and someone says there wasn't. For example, if a gentleman dies and a lady comes forward and says we were common law married, and his heirs might say no, they weren't. And the reason that there's this difference is because if they were married under South Carolina law, that lady would have a right to some of the property. But if they weren't married, she wouldn't have a right, and those children would get all of the property. And so that's why there may be a dispute in probate court about whether someone was common law married. Another common example is in family court when two people are divorcing. And because the male has typically been the breadwinner, so I'll use the example of the man has 10 acres of property that he acquired while he and this woman were living together over the last 30 years. They're divorcing. If they're married, she has a right to half of that property under most circumstances. There are a few exceptions. But generally, if that's marital property, she has a right to about half of that. If he can prove they were not common law married, then she has no rights to that property unless it was put in her name. So that's a reason that there might be these disputes about whether people are common law married or not. So if you're trying to prove that you were common law married in South Carolina, you have to show that you intended to be married before July 24th of 19, and so did your partner. Also, you have to show that you held yourself out as married. So what that means is you are presenting yourself as a married couple to the public. So one example of that could be at church. You both join a church and you say, husband and wife, here we are joining the church together. Sometimes people share last name as a way to show others that they're married. Sometimes people introduce their partner to their coworkers as this is my wife or this is my husband. Sometimes on life insurance documents, people will say that they want their proceeds to go to their husband, Bob Smith. And so all of those things can be proof that you held yourselves out as married. You also have to prove that neither of you had any impediment to being married. So I had mentioned that briefly before. An impediment is a reason you cannot legally marry. And if you can't legally marry in a ceremonial marriage, you also cannot legally marry in a common law marriage. For example, if you are currently married to somebody else, you cannot enter into either of those types of marriages. And then if there's a dispute, the family court and the probate court have the jurisdiction to decide whether or not you were common law married. And so here's some examples of proof that people often use. But just as a reminder, just because you maybe said my husband on your insurance document that's not enough to say common law married. When this goes to the courts, they look at all of the information together. And so that case that I mentioned earlier, the big 2019 case that made a lot of changes in common law marriage, they had some facts on either side. One party who was trying to say we were common law married pointed to some legal documents where they said they were married, and then the other side pointed to some legal documents where they made it clear that they were not married. And one side said, here are my witnesses. They say that I introduced this person as my spouse. The other side said, no, here are some witnesses. They can testify. I said I was never going to get married again, and that this is my boyfriend or my partner. So there's usually, all the proof does not always go one way. There's usually some dispute and some differing documentation. And that's just another reason that the court decided, let's make this simpler, not so much question of what's really going on. And for the future, you'll not be able to enter into a common law marriage. But once again, if you entered into it before July 24th of 2019, you can still be common law married in South Carolina. So here are some different types of law that could be affected by whether or not you're common law married. We talked about the inheritance example, immigration. If one of you is immigrating, it's important to know that determination about whether or not you're common law married could have effects on your immigration. Alimony. Alimony is money that one spouse pays to the other under some circumstances when the parties separate. That does not apply at all if the parties were never married. It can apply sometimes when the parties are married, but if the parties were common law married, they first have to overcome that burden of showing that they were common law married before they can get to the part where they prove that they may be entitled to alimony. So if they were not at all common law married and not ceremonially married, there will be no alimony. Another issue is property and asset division. That was the example I gave where the gentleman had 10 acres. Under most circumstances, the wife would be entitled to about half of that marital property, but if they were never married, there's no marital property. Name change, whether you're married, going through a marriage or divorce, it's an easy way to change your name. There are other ways to change your name, but those are typically the easiest ways. Taxes. Some people file their taxes as married, even if they don't intend to be married. And sometimes they'll do this for tax benefits, or they will file separately for tax benefits. Just because someone filed a certain way, their taxes does not automatically answer the question of whether their common law marriage. It's just part of that totality of the circumstances. They look at all of the evidence and then decide. So it's just one thing that the court would look at under those circumstances. But they did mention in this court case that they were frustrated with these parties for sort of picking and choosing when they're married and when they're not for their own financial benefit. And it's just another example of why it should be a little more clear whether people are married or not. Could also affect liability for a partner's debt if they're a spouse. Life insurance, whether they're entitled to life insurance, whether someone's entitled to health insurance. If you work and your husband needs health, your husband or wife needs health insurance, under most insurance plans, being married makes that easier. Custody of a child before a custody hearing is interesting. In South Carolina, an unmarried mother naturally has custody until the father steps up and asserts some of his rights. He can then get custody. And once it's in front of the court, it's an even between mom and dad. But if they're unmarried, then mom automatically has an advantage. And so in some cases, mom might decide she doesn't want to be common law married for that reason if the parties separate. And also for healthcare decisions, when people are maybe at the end of life or cannot speak for themselves, being married could have an advantage in what impact that partner or that potential spouse has in making those decisions. So those are just some ways that whether you're married or not, it could have an impact legally. I wanted to address some common questions that I've heard. What if you change states? So within the United States, the states have to recognize something that's valid in a different state. So if you got married in a state that recognized common law marriage that occurred after 2019 and then moved here, South Carolina would have to recognize it if you are legally married in the state you came from. So if you were common law married here in South Carolina before July 24th of 2019 and then moved somewhere else, that state would also have to recognize that you were common law married, because under South Carolina law, if you are validly married in South Carolina, they'd have to recognize that. Now, that will probably determine, if people disagree about that, some sort of judicial decision declaring. But often people do agree on whether they're common law married. It's just sometimes when they don't, that you need a judge to come in and make that decision. Another common question is whether people can be common law divorced, and the answer is no. Just because you can be common law married by your actions and how you present yourself to people does not mean you can be divorced that way. You can't just make it go away. So if a court declares you common law married, that means you have to go through the family court process to get a divorce, just like you would if you had a ceremonial marriage. Can a same-sex couple be common law married? Yes. In South Carolina, if you entered into that common law marriage before July 24th of 2019. Do you have to be married a certain number of years? For some reason in South Carolina, there's this myth that you have to be together for 7 years to be common law married. That is not true at all. There's no requirement for a number of years in South Carolina. As I mentioned, they just look at all the evidence. Now, of course, the longer that people are together, probably easier to prove that they were common law married to an extent, but there's no specific amount of time. It's possible that somebody could prove they were common law married if they were only together for 6 months, for example. So there's no minimum amount of time you have to be together. And then some people say, well, what if I didn't know the laws about whether I was common law married at the time? The court case says that's not an excuse. It will all go back to whether you and your spouse intended to be married. You had that intent, that mutual assent to be married, and then held yourself out that way. So that's the determination. You didn't have to know what all the legal requirements are, or maybe if you thought you had to be married for had to be together for 7 years, that's an error. That's not correct. That's not going to make or break that decision. It all goes back to whether you all intended to be married. So sort of the bottom line here is that you cannot start a common law marriage in South Carolina after July 24th of 2019. But if you started it before then, you can still be common law married. And that whether you're common law married or not can have broad effects on your life in many legal areas. You should definitely seek legal advice if you need more information about how this can affect your life. And here's some contact information to apply for our services. That's our intake service, the 1-888 number. So you can call that between from Monday to Thursday from 9 to 6. You can also apply online. And then we've also provided several websites with different legal information, such as videos about, such as this one, or brochures we've made that for topics you may be interested in. And if you belong to a group and that you believe that group would be interested in a presentation such as this one, please do contact us and we'll be happy to arrange that. Or you may have other legal topics that we may be able to present on. South Carolina Legal Services is a nonprofit law firm. We help primarily people with low income, and we work on civil issues, which means not criminal legal issues. All right, I'm going to glance at the questions and see if I have any here. Don't see any questions.
So we have any questions at this point. So I think you probably answered all of the frequently asked questions. So thanks so much.
Thank you so much for this opportunity.
You bet. I want to thank you so much for the presentation, and thanks to all of you who did join us today. We certainly do appreciate your interest in this subject matter and in others. And this was a really interesting presentation on the abolition of common law marriage in South Carolina. So Leslie Fisk, thanks for such a really interesting presentation. I want to remind everybody to remember that Level Up Law is a series of free webcasts. We do this every Tuesday at noon to educate the public on some of the common legal issues that we see here at Legal Services. All of these can be found on our YouTube channel. Just go to the Level Up Law playlist at SC Legal Services on YouTube. And while you're there, if you found this or any other presentation helpful, be sure to give us a thumbs up and also share the broadcast with others if you think that they would be interested or it would be helpful to them. And while you're there, if you go ahead and subscribe to the channel, and sign up for alerts, you'll get a notification every time that we post a new episode. And of course, we're doing that every week. And Kenneth will post this one shortly. And also, we invite you to leave comments there if there's another subject or related subject that you'd like to hear about. And again, Leslie mentioned the information here on the slide about how to get in touch with us. We have great staff there at our intake office. They're always standing by Monday through Thursday, 9 to 6. And we also have a Level Up Law episode that is, I think, very helpful when you are applying online. It gives you some of the tips that you'll need to know if you are applying online rather than by telephone. So definitely be sure to check that out if you're in need of representation. Now, I want to announce the subject matter for next week. John Ozolins, our lead foreclosure attorney, will be sharing information on reverse mortgages. So be sure to register and join us. You can do that on our Facebook page. You can click the link in our bio on our other social media channels. So if you're not already following us on social media, definitely do that. We're giving you the information right here on this slide. So we have a lot of, as Leslie mentioned, good information on these episodes, but also on all our various websites. So definitely check it out. And thanks again for tuning in to Level Up Law today. We look forward to having you back with us next week. And let me thank you once again, Leslie Fisk, for a great presentation. And that concludes today's webinar. Thanks for tuning in, everyone.